Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McInnes Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. Once Canada's Strong Borders Act is passed, electronic service providers, your email host, your cloud storage company, maybe even your ISP may be ordered by the Minister of Public Safety to change their systems in ways that facilitate surveillance. And here's the kicker. Those orders are secret. The companies aren't allowed to tell you that it's happened. So the government can secretly jack into your email system, your cloud data system, instant message systems, and you would have no way of knowing. The big telcos, their core providers, they're going to be subject to public regulations under the proposed Supporting Authorized Access to Information Act. But for the rest of the internet ecosystem, there are secret orders. I described all this in a previous episode, which I'll link to below. Now, here's where the idea of a warrant canary comes in. And I think everyone who provides digital services in Canada should start thinking about them now. A warrant canary is a clever transparency tactic. The idea is pretty simple. A company regularly publishes a statement saying something like, "We have never received a secret government order." Now, a whole lot of regular production orders have a limited time gag order, so Canadian companies might want to say, "We have never received a secret order under the Supporting Authorized Access to Information Act." And as long as that statement stays true, they keep posting it, maybe every week, every month, every quarter. They'll post it with a date, sometimes with a digital signature. If that statement suddenly disappears, or if it stops being updated on schedule, users can infer that the company has received such an order and can no longer truthfully say that they haven't. The name, of course, comes from coal miners used to bring canaries into the mines. And if toxic gas was present, the canary would die before the miners were affected. In the same way, the disappearance of a warrant canary is meant to be an early warning. And it's probably not technically violating the secrecy provisions of the Act, since it's not technically disclosing or stating, quote, the fact that the electronic service provider is subject to the order, which is prohibited under Section 15 sub C of the Act. Of course, I would expect that the government would argue that removing the warrant canary would be doing the same thing and thus violating the law. Now, I first heard of warrant canaries in the early 2000s after the U.S. passed the USA Patriot Act, which allowed for national security letters and other secret orders that came with gag orders. People on privacy mailing lists, like the old cypherpunks list, were brainstorming ways to signal to the public without technically breaking the gag orders. At the same time, companies like Google were really innovating with transparency reporting on how many warrants and other government orders they were receiving. But they were prohibited by law from disclosing whether they'd received any of these super secret orders. It wasn't clear whether warrant canaries were fully lawful, but it became popular among privacy-minded companies as a form of self-help transparency. Here's an example that was put up in a library in Vermont in 2005. I think it's absolutely brilliant, and the photos by the amazing Jessamine West. One of the first online examples was rsync.net back in 2006. They published a regularly updated canary. It was digitally signed, and it was also accompanied by the current news headlines to prove it wasn't pre-written. Here's the most recent one from August 8, 2005. In 2013, Apple included in its transparency report a line saying that it had, quote, never received an order under Section 215 of the USA Patriot Act, unquote. In later reports, that sentence was gone, and that disappearance got a lot of attention. Tumblr tried a canary in 2014, and SpiderOak, a privacy-focused cloud provider, published one that was GPG signed and co-signed by multiple executives. Reddit famously had a line in its 2014 transparency report saying that it had never received a national security letter or a FISA court order. In its 2015 report, that sentence simply wasn't there anymore. And the press noticed. But warrant canaries are not without problems, and I can't say it's a legal slam dunk. First, on the legal side, in some jurisdictions it's not clear whether removing a canary would be seen as illegal disclosure or whether the government could compel a company to keep publishing a false canary. That runs into freedom of expression issues. In Canada, a company can't generally be compelled by the government to say something, particularly on a matter of public interest and particularly something that's not true. However, national security tends to hold a lot of weight for judges, and deference is often given to governments. That deference may be given unduly, perhaps. As I said in the previous episode, I have a real problem with the automatic unlimited gag orders for every single ministerial order given to an electronic service provider. The capabilities required of core providers, as I said, will be published in public regulations. Everyone can see it. But if the minister orders an electronic service provider to do the exact same thing, that is subject to an automatic gag order. If it's the same thing, what's the harm in making it known? Now, I get that some orders may involve super sneaky, Weasley in the shadows techniques, but gag orders should be reserved for circumstances where making it known would reasonably be expected to harm national security. At the very least, these orders should be time-limited and subject to judicial review. And during judicial review, the government should be required to justify them. Secrecy by default is not okay. In Australia, for example, laws explicitly prohibit disclosing either the existence or the non-existence of certain kinds of warrants that target journalists, which effectively bans warrant canaries, at least for this one kind of warrant. Whether Canada might consider following suit, don't know. Second, canaries can fail for non-government reasons. A company might forget to update it or change its reporting format, causing a false alarm. Now, there was a project called Canary Watch, run by the Electronic Frontier Foundation and others to track canaries across the web. That domain has since expired, but check out canarywatch.org on the Internet Archive's Wayback Machine to see all the warrant canaries they were trying to track. Apparently, they shut it down in 2016, partly because monitoring them was unreliable, and they said ultimately the project achieved its objectives by raising awareness. So would a warrant canary help in Canada under Part 15 of the Strong Borders Act? Maybe. It could give privacy-minded companies a way to signal to their users if they've been compromised without directly, technically breaking a gag order. But as I said, I would expect that the government would argue that removing a warrant canary would be indirectly violating the confidentiality provisions of the Supporting Authorized Access to Information Act. But it's no silver bullet. A warrant canary is only as trustworthy as the company running it. At the same time, for a company sending out the message that they've been subject to a secret government surveillance order, that might be bad for business. And they, of course, can't disseminate any information about what the government has ordered them to do. It could be really quite bland along the whole spectrum of things the government can do, but they can't say a peep about it. So while the Canadian government expands surveillance powers while restricting what companies can say, tools like warrant canaries remind us that transparency is a fight worth having, and maybe we want to think about it in advance and proactively. Because I really should emphasize that Bill C-2, the Strong Borders Act, which contains the Supporting Authorized Access to Information Act, it's still in Parliament. There's still an opportunity to voice your concerns about the Act generally, and these gag order provisions in particular. I hope this has been interesting and useful. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.